Good afternoon, Senator Pate. It's very nice to see you today.
It's wonderful to join you, Maya, and please just call me Kim. And I'm happy to join you. I'm here on the shores of the Kitchissippi, the unceded, unsurrendered, unreturned territory of the Algonquin Anishinaabe.
Thank you for the acknowledgement, and that will be one of the things that we will be talking about today, the Indigenous people's rights. But I'm honored to have you as my guest. Many of the issues that you advocate for and that you're a very fierce advocate for are issues that I'm interested in, but that I know many of my colleagues, criminal defense lawyers, are also very passionate about. So I'm really excited about the conversation that we're going to be having today. The main areas that I would like us to talk about are the jail and prison issue, which seems to be a never-ending issue, Indigenous rights and ethnic minority groups in the criminal justice system, and finally, women in the criminal justice system, the different treatment of victims versus accused females. But let's start with the jail and prison issue, Kim. Um, Sadly, it seems like almost every week at least, a breaking news about some horrible jail issue. Lindsay is now one of them. We had Maplehurst with some
Yeah.
horrible videos. Why do we have this problem? What's going on with the jails?
Well, I think anytime you have a system that's closed where people have power over others, you run the risk of abuse. And because we don't have transparency or accountability within our prisons writ large, we see this. And one of the things we've recommended that is at the federal level, because of course I'm at the federal level, not a
Yes.
provincial level, is what we've called Tona's Law. And part of what we'll send out to you are the materials that we've been working on. Now, Tona's Law is, we've named it after a woman who spent 11 years, nearly 11 years in isolation, in segregation in federal prisons, and then was diagnosed in the mental health system as having isolation-induced schizophrenia. And the reason I raised Tona's Law is because it's what we looked at there was we went back to the recommendations that Louise Arbour, now our Governor General, made 30 years ago when she
Yes.
finished the Commission of Inquiry into the events at the Prison for Women. And two main things she called for was accountability, judicial oversight of corrections, and a remedy for prisoners where the way they're treated amounts to correctional interference with their lawful sanction, their sentence. I think the same kind of remedy could be available in the provincial and remand context. In fact, it kind of is and always has been. It was curtailed by legislation under the Harper government when the ability to negotiate reductions in sentence at the time of sentencing were some of that was curtailed, and you may recall, or some of your listeners will recall, where some people might get as many as 3, 4, or 5 days for every day in remand, depending on how horrible and unlawful and human rights violating and charter rights violating the conditions of confinement were. Tona's Law would actually bring in a similar sort of process, but after sentencing, so that if the way someone is treated in the federal prison system amounts to interference with their lawful rights, whether they're kept in segregation or structured intervention units or isolation by whatever name for extended periods, whether they're kept at a higher security than they need to. We know that in Ewart and other cases, the security classification system and risk assessment system has been found to be discriminatory on the basis of race, as well as sex and ability, particularly when we're talking about people with mental health and addiction issues. And so at the Senate, we've done in 2017 to 2020 21 really, but it was accepted later. We did a study of the human rights of federally sentenced persons and recommended a number of these things. As I say, they weren't original ideas. These were things Louise Arbour had recommended and others. There were recommendations of the Truth and Reconciliation Commission and the
Mhm.
Missing and Murdered Indigenous Women and Girls Inquiry. And so it would require that kind of oversight. It would require limits on the use of segregation or by any name. not just structured intervention units. And it would also increase the what I call the off ramps out of the prisons. And so in the federal legislation, there are provisions to allow for people to be transferred out for health reasons under Section 29 of the Corrections and Conditional Release Act, and under Sections 81 and 84 for people to be serve their prison sentence and paroled, respectively, in particularly for Indigenous people and Indigenous communities. But the subsections of those also allow them to apply to others. And so in this bill, Bill S205, that we've subtitled Tona's Law, it looks at oversight remedies and alternatives within the federal prison system. I think many of those could be mirrored in the provincial systems as well. So that's one of the things we're working on. We also have a bill that's sitting dormant right now, and but on the books, a judicial discretion bill, we call it, Bill S208, which really is to breathe life into the Truth and Reconciliation Commission recommendation number 30 to 30. Is it 30 or 32 to deal with mandatory minimum penalties and
Mhm.
allow judges to apply Section 718(2)(e, often referred to as Gladue factors, so that individuals are not necessarily subjected to mandatory minimum penalties. Anybody who wants to listen to my third reading speech on Bill C-16 will hear me talk about how we have failed to fulfill those obligations. And that was a bill that came out following discussions with a number of successive federal ministers of justice, and not seeing the kinds of changes that were recommended by the TRC and by many court cases, and I would argue the Supreme Court of Canada itself. So that's another, and we're also working on one to allow criminal records to expire, which would impact, of course, at every level.
Yeah.
Uh, and that one is Bill S207. Again, it was one I was working on with the government, and it was a commitment the government made, the Liberal government in 2015, to repeal the record suspension provisions that had been brought in by the previous government, and that bill would allow, if it ever saw the light of day, it would allow criminal records to expire rather than people having to apply for them,
Yeah.
pay costs,
Yeah.
even a small application fee like the current $50 doesn't take into account all of the other records that you have to obtain, the fact that you may have to travel to get them,
Mhm.
and the fact that the application process is so complicated that the government is now spending $18 million per year to get community organizations like John Howard, Elizabeth Fry, St. Leonard's, and others to assist people to fill out application forms. So that's another one. And then the work that I came to the Senate to do was the guaranteed livable income, and how do we breathe life into the Charter of Rights and Freedoms when it comes to what I think of as human rights to housing, income supports, health supports, including mental health supports, as well as housing and social supports.
So these are all very important issues, and obviously, criminal defense lawyers, we deal with these issues on a regular basis, sometimes on a daily basis. So we understand their importance. But I find the frustration is sometimes that there isn't that appetite from the general public or from other politicians as well when it comes to these issues. But why is that? And that's really frustrating because that also prevents these issues from taking center place in the debates and in coming into effect.
Mm-hmm. I mean, the only times that I've seen them come into the forefront here is when you see massive abuses like the
Yeah,
situation in Maplehurst, and especially when videotape is leaked out. I mean, that's exactly how we managed to get the incidents that gave rise to the Arbor Commission any response, because there were videotapes that were leaked to the media. It was shown on Fifth Estate back
yeah.
in 1990. January 1995, and that led to the Arbor Commission. And then, her publicizing that here you had the correctional investigator, I was part of Elizabeth Fry at the time, saying one thing, and then you had corrections saying a diametrically opposed
Hmm.
situation. So one of the things that Louise Arbor has also said since then, it's not squarely in the report she made, was that anybody working in and around the criminal legal system. I don't call it a justice system because there's not much just about it.
Yes, I agree.
But, and she said that, whether it's police officers, defense counsel, crown prosecutors, judges, or legislators, people like me who either are members of parliament or senators, we should know what the conditions of confinement are. So, one of the things that I've been doing, my first speech in the Senate almost 10 years ago now, was about the fact that senators, members of parliament, and judges have a right of access to our federal penitentiaries. So we've done this little report, which we'll also send you, called Senators Go to Jail. And it literally was 51 senators have gone into the prisons. And I think it's fair to say part of the reason Tona's law passed through twice now through the Senate and is sitting in the House of Commons. It died on the order paper last time around. But First Nations member of Parliament, Leah Gazan, is the sponsor of it now. And she is, she is planning to uh, try, she's committed to getting it through Parliament. And part of the reason that politicians aren't that interested is, quite frankly, the stigma that attaches
Yeah,
to crime and those who have been criminalized and incarcerated. They're not a public that the members of parliament are particularly concerned about, or elected officials generally. And I would have to say, even senators. I mean, we have more interest in the Senate, in large part because senators have gone into prisons and have seen the conditions, have met with administration as well as frontline staff, as well as prisoners. And they see the concerns and they see their very real need to change things. But for the general public, it's not the kind of area. Many people have the attitude that if people don't want to be in jail, they just shouldn't do the crime. And that misses entirely the fact that our jails are full of people who are failed by every other system. It is not. It is not definitely a cross section of those who cause the greatest harm.
yeah,
And in fact, we know that those who have the greatest privilege and resources often are able to hire a phalanx of lawyers and experts and avoid criminal responsibility, even sometimes when they've committed very heinous acts. And so, I think part of it is also in ensuring that the general public recognizes that. And it's as you know, and your colleagues well know, that is not easy. And in my speech on C16 at third reading, I talked about the fact that my work in prisons started from working with young people in care in the child welfare system, predominantly those who had been in abusive situations, incestuous, as well as other forms of sexual and physical abuse. And it was really watching what happens with those young people. Many of them, especially the young women, end up on the street, being trafficked
yeah.
and traded for sex. And then many of the young men became perpetrators of violence if there were no interventions or other supports put in place. And that, to me, and as they aged and ended up in the system, we saw that really pernicious divide and dichotomy about how you treat people who are victims first and foremost, but then once they act to either protect themselves or to ward off attacks, or to model the behavior that they've been taught since being very young through the abuse of themselves, that we quickly criminalize and incarcerate them. And so that idea that we don't fundamentally deal with the victimization or prevent it in the first place, and that we villainize those who in any way end up trying to negotiate those spaces. And one of the other pieces that I'll send is this injustices and miscarriages of justice experienced by 12 Indigenous women. Every one of these women are women I've known for a long time. Each of them was either themselves in residential school or they're first or second generation. All of them were abused as young people, and most of them as women as well as adults as well. All of them had child welfare experience as well. And all of them were criminalized for trying to navigate or survive poverty and or the addiction that goes along with anesthetizing yourselves to the reality and past trauma of abuse, and or fighting back against violence that they were experiencing. And I often use Jamie Gladew's case as an example. Most people know the Gladue decision
Yeah.
because it was the first time the Supreme Court of Canada considered Section 718 2E of the Criminal Code. Most people don't know, however, that the facts as they're articulated in uh, in the case do not resemble the reality of her lived experience. Jamie was a 19-year-old pregnant with her second child by a man who was so abusive he had actually been jailed previously for abusing her. She had been moved from her home in Calgary to Nanaimo on Vancouver Island to get her away from her family or community of support. Her father, who was a single dad, had been clean and sober for a number of years and raising her younger siblings, was so concerned about her safety. He moved himself and her other siblings to Nanaimo to try and help protect her. And he had a rule that none of the other children were allowed to be left alone with Reuben Beaver. The night Jamie stabbed him, he had first beat her up. He'd then gone next door, broken in through the bedroom window, raped her sister, came back, told Jamie about it. And when Jamie stabbed him, he was trying to get back in through the front door of the unit where her sister was. Now, most of us would characterize that at the very least as defense of other, and and I would say self-defense as well. And yet she is characterized and villainized as a jealous wife who stabbed her common law because he was having an affair. I don't see that is an incredibly misogynist um, and I would say racist interpretation of that situation.
Well,
And
sorry to interrupt, but this also touches on one of the issues that I wanted to discuss actually with you, Kim, and it is how a person, the same person who can be a victim and suffering from so much trauma, the moment they are in a situation where they are accused of a crime, the treatment and the look and the judgment completely changes, which is really unfair. And I understand that sentencing eventually is where we take into account all the personal circumstances. But before we even get to sentencing, there's all the stigma, the judgment, and it's almost like there's no presumption of innocence that applies to people who are accused when it should apply to them in particular. But why do we have this problem?
well, I think it's fundamentally about discriminatory attitudes,
Hmm.
about, it's about poor people, it's about
Yeah,
racialized folks, especially Indigenous and Black
yeah,
people. It's also about women. The idea that
yes,
if a woman uses violence, she must be way more problematic and violent than even a man. And so that's how we end up now with 1 in 2 women serving a federal prison sentence of two
yeah,
years or more are Indigenous, disproportionate number for serious violent offenses, and many of them in for killing abusive partners or for using lethal force in response to attacks on either someone in their care or themselves. Uh, and and as you know, once you have a mandatory minimum penalty, which you have the minute you use a weapon, if you're a woman or a child who's experienced abuse, your ability to fight back in any kind of defensive way with someone who may be much bigger, much stronger, who may only need to use their hands and their feet to kick, to stomp, to choke, to punch, you probably have to pick up something, whether it's a
yeah,
hairbrush, a frying pan, a plate, or a knife or their own gun to ward off their violence. The minute a weapon is used, it's a mandatory minimum of 5 years in
yeah,
prison. And once you have mandatory minimums, it's very difficult many judges feel they would like to be able to apply 718(2)(e), but essentially they're precluded. They have a mandatory minimum to apply. And so and the fact that we now, with Bill C-16, have just reintroduced a number of mandatory minimum penalties that have been struck down by the Supreme Court of Canada and other courts, and instead of repealing them, I think is a significant problem and one that we should all be concerned about. And
yes,
and I think the stigma also attaches to defense counsel often,
yeah,
that if you're defending someone,
yeah.
the presumption is that somehow any
You're
behavior that may have
defending
been,
the crime.
that's right.
Exactly.
That's
It's
right.
it
And
it
And judges. We're seeing it now applied to judges. I mean, we have the premier of our province saying that judges who apply the law and ensure due process and the rule of law is respected are somehow activist judges as opposed
Yeah.
to doing exactly what they're expected to do, which is apply the law and ensure that people have access to fair and due process.
Well, but on the point of mandatory minimum, since you brought it up, it is a really important point because it does seem to be contradictory with the whole premise of what sentencing is. Because sentencing is all about tailoring a specific sentence to the circumstances of the accused and of the case. But when there's a mandatory minimum that applies regardless, it just is inconsistent with what sentencing is essentially. And this is what I find sometimes that I struggle with still as a criminal defense lawyer, as how can we have a mandatory minimum sentence when sentencing is all about taking into account the particular and specific context and circumstances of the individual. So I don't know how to reconcile the two.
It's because they are largely not reconcilable. I
Mhm.
mean, the when I first started doing this work, there were fewer, you could count almost on one hand the number of mandatory minimum penalties that existed in this country. I think there were 7 at the time. Now, I don't even know what the current number is. The
Yeah.
last time we counted, I think it was 87.
Mhm.
And now with Bill C-16, we've got more and a very, very limited what they're calling an escape or a safety valve. It's not much of a safety valve when you have to go beyond a charter description of cruel and unusual punishment to establish that a sentence would be wrong. And this interferes with the ability of you as counsel to argue for a tailored sentence. I think it interferes with the discretion of Crowns as well, because there will be increasing pressure for people to plead guilty, and Crowns will be complicit in that. And I think that's not what most Crown prosecutors, who are certainly all of the Crown prosecutors I know who are responsible and want to be responsible in the application of the law, they know that that's taken out of their hands. They can't even tailor it to, for instance, what the issues for a victim may have been. And then you have the judge is the person who has heard all of the evidence, and is tasked with weighing all of that evidence, deciding, what the appropriate penalty is. And why do we even have judges if we're going to
Exactly.
take the discretion
Yeah,
out of their hands?
exactly. I mean, is it ultimately, unconsciously, is that the ultimate goal to get rid of the people who are doing the work? Because it just seems on the defense side, there are more and more, the rules are becoming and the laws are becoming stricter. We have stricter bail uh, laws that are coming. We have these harsh sentences, and it's almost like telling us defense lawyers that you're useless. I mean, that's how sometimes I feel. It's just so crushing sometimes with these tougher laws. And to be honest, I don't know if toughness is what it takes to get rid of the problem. I mean, I think it's counterintuitive what is happening here. And I understand, obviously, there is a public safety concern in some types of crimes, but I don't know if being necessarily tougher is the solution.
Well, it's counterintuitive to you, and it also defies all evidence. All the evidence shows, including Department of Justice, the Federal Department of Justice own research on things like deterrence. And
Mhm.
the reality is we know sentences do not deter crime. There is no evidence, no credible evidence. And it really is rhetoric and political expediency. And I would say not transformative work, but performative policies that have taken on. So when you have the opposition talking about bail as a catch and release, and that you don't actually have meaningful accountability, that's a catchy phrase, and the public picks it up.
Yeah.
When you see more and more people in the street because they're homeless, and you may feel uncomfortable because they may ask you for money, or they may be anesthetizing themselves with drugs or alcohol to deal with that reality, that makes people uncomfortable. There's a perception that these are the folks who are causing the greatest harm. And so it becomes easier for the politicians to succumb to public ideas and attitudes that may have no basis in reality. And that's what we're seeing. Bill C-14 and C-16 were based on calls for more stringent, more punitive, longer sentences with no evidence that that would be effective. In fact, quite the opposite. All of the evidence shows
Yes.
that the last three bail initiatives that were brought in that were more punitive and more restrictive, in fact, resulted in more people in prison and disproportionately more racialized people in prison, more young people in prison. And now we'll likely see more of that. And as we see the ramping up of these issues, people are saying, well, it'll get them off the streets. We know, for instance, car theft. Car companies have testified before our committee that they could actually put in place a mechanism within cars to help deal with car theft.
Mhm.
Obviously, it's not in their interest to do that. If
Yeah.
a car is stolen, someone gets insurance, they buy a new car,
Yeah.
and so we hear about young people. We just saw, a few weeks ago, a number of young Black men who were disappearing and were being trafficked into, almost a Faganistic type
Yeah.
of situation, recruited in to commit crime. Now, do I think it's okay that that's happening? Obviously not. But do I think that targeting those young people and putting them in prison for longer periods will solve it? No. I mean, the people who are engineering these approaches will just go and recruit more young people. And so it's part of why, I keep advocating that we actually have to look at the inequality that exists, address those issues, and then we're more likely to see more people dealt with in the community in a positive way. We're likely to see less costs for things like emergency health care, less crime, less victimization, lower incarceration rates, and overall a better standard of living for everybody. Why wouldn't we want that for everybody?
Exactly. I totally agree. And this is one of the problems that I see in the practice of criminal defense is that there's never we hardly ever address the underlying issues that are bringing people before the criminal justice system. And I mean, I don't know who is responsible for that here, but it is frustrating because many of the crimes that we see on a daily basis can be avoided if we address the underlying issues. But again, it's not much is being done on that front, but yet we want to punish even more the people who find themselves in front of the justice system. But what would you tell us to do more? I mean, I sometimes
Yeah.
feel frustrated about the situation, Kim, and I just don't know what else. What should we do more to push people to realize that we need to fix these issues that are causing people to commit these crimes?
Well, I say whatever you can do is great, and by no means I see it as part of my job. If your listeners watch the debates on Bill C-14 and C-15, you'll
Mhm.
see, or C-16, sorry, you'll see a number of us speaking out, a number of us voting against, and the challenge is really to keep educating the public and demand that our elected officials do their job. It used to be that we would expect if a government was asked to do something that they knew there was no evidence that they would be an effective response, that part of the job is to educate the public about
Yes.
why either the situation they believe to be true is not true, or and or then address the issue in an appropriate way. In this context, we're focusing all on the criminal legal system, and there's at page I think it's page 4 of this report that we did, we put in a chart. It was actually after I'd been asked to talk about the incarceration rates of Indigenous people. And you can just see the chart. This is the representation of Indigenous people in prison. Initially, it wasn't even disaggregated by sex or by gender. Now it is. And what's on the bottom bar that people look at is many people are saying, well, we need, I spent about a month or more ago, of a day in the courts in Toronto. I wanted to see what was happening in the mental
Yeah.
health court, the Indigenous. Great work being done. But the more we add into the criminal legal system, the more we increase the likelihood that we'll see more folks inside. And so what's on the bottom of that chart is, the healing lodges, the fact that we have mental health courts and other special circumstance courts, the fact that we've had Gladue, IPELI, the fact that we've had amendments to try and address these issues. And the point we're trying to make is that instead of keep adding into that system, we actually have to demand something that often criminal lawyers, you think about, but you don't think of as part of what you might want to advocate. And that is, how do we build up the community? How do we ensure that we have adequate housing, adequate income supports, adequate places and options for people to participate in the community instead of leaving them homeless and in encampments. And oftentimes, believe me, I know you are all worked off your feet, but the more you can remind judges that, the context of this person being in this situation is really one of social inequality, as well as likely racial, gender, and ability in terms of mental health and addiction issues. I think it's really important to get on the record, even if there is a mandatory minimum. And sometimes it's hard because judges will shut you down.
Yeah.
But I do think we have to continue to get these, to have these situations documented. And then, many of your colleagues provide excellent testimony before our committees. That's really important. And anybody can do that. If we are studying a bill, and even if you're not called as a witness, and these last two bills, we were going so quickly through them that most people who were called couldn't rearrange their schedules. If you're in court, you can't just up
Yeah.
and leave for
Yeah.
an hour to go testify. And so sending written submissions is always helpful as well, and documenting these things. And as well, when people come knocking at your door for votes, demanding what their positions are on these kinds of issues is really important. And if you need the factual materials, get hold of folks like me and others who will provide you with that data to say, here's all the evidence that shows this shouldn't work. And I'm often encouraging council to bring charter challenges, even in cases that seem less important in the scheme of
Hmm.
things. But for instance, Jamie Gladue did not go to prison in large part because we did not yet have a mandatory minimum for weapons charges. She used a knife. She grabbed a kitchen knife and used it. Had her case happened, even I think it was 6 or 7 years later, she would have had a mandatory minimum of five
Yeah.
years in prison.
Well,
Excuse
one
me.
thing,
Excuse me.
sorry.
Sorry.
Um, and I am mindful of your time, but I do want to ask you about one point, Kim. But do you think that maybe there's also an over-criminalization of behaviors? I mean, not everything must be characterized as a crime. There should be maybe consequences, but not necessarily the criminal justice system. And that is also frustrating that I see with clients. Sometimes they'll do acts and they say, but why is that a crime? Why do I have to go through the criminal justice system for that? So maybe also we have a problem of over-criminalization as well.
Well, I call it, especially when we're talking about the Indigenous women that I've known, we talk about the hyper responsibilization and
Mhm.
criminalization. What I mean by that is we essentially deputize some people to protect themselves, to take care of themselves. And I often, when I used to teach in the law schools, I would talk about, when we get to talking about prisons, I'd talk about and crime. I'd use a quote from Anatole France, who was a French philosopher
Yeah.
in the 1700s, and he said, it is just, I'm paraphrasing, but he said, the law applies equally to everyone. Nobody is allowed to steal bread or sleep under bridges. Well, when you say it that way, you get very clearly who is most likely to be criminalized for those
Mhm.
behaviors. It certainly isn't people with resources and money. When you think about who gets criminalized for um, everything from theft to fraud to break and entry. It's generally not the people who have the resources that are doing that.
Yeah.
And again, it's not to excuse behavior, but to say, or to condone behavior, but to actually say, in this context, what would you be doing if you were in this young person's, this adults, whoever it is? And it's part of the reason why many of the First Nations are talking about returning to some of the traditional ways they would deal with things. And so, even things like involving personal violence or crimes of violence between people, they would talk about if you harm someone, you then have a responsibility to take care of the people who that person was responsible for, either for until they're able to do it again themselves, or if you kill them, then forever you
Yeah.
now assume a responsibility. Uh, there are all kinds of other examples that people like Val Napoleon at UVic and others have talked about, where we should be looking at how do we hold people accountable in ways that encourage changes to behavior. That's the theory. One of the
Yeah.
theories of sentencing is that we're trying to correct and rehabilitate.
Rehabilitate. Yes.
Um, but we're talking about people who rehabilitate, of course, comes from the French word to redress. Well, if you were never dressed in the first place, you never had those
Yeah.
opportunities, then how do you redress them? And so one of the challenges is really about building up community. And so again, I go back to saying, one of the things we have to do is insist on dealing with the inequities in income, in housing, in all of the very measures that allow people to have a more equal application of the law, if and when they then do something that is truly dangerous and harmful. We end up scooping so many people up into the prison system because they have mental health issues, because
Yeah.
they're annoying, and because they commit petty crime. Again, it doesn't, it's if it's your house, and I've had my house broken into. It's not pleasant, but when that happened, I said that I wanted, if they ever located whoever it was, I wanted to have an opportunity to meet with the person. I would put them to work. I would figure out ways to resolve it. That the last thing I would want, and the last thing that would help me or anybody else, is to just put those people in prison if they're breaking in to steal something to sell,
And yeah.
whether it's for food or for because they've become addicted because of all of the other deficits in their life and trauma that they've
And which
experienced.
will not necessarily also prevent them from engaging again in that type of behavior. I mean, it's not teaching them much. Uh, if anything, it's just making them become even more angry against the system. Um, I want to thank you so much, Kim, for taking the time to chat with me today. I promise I won't take more than an hour of your time. So I know that you're very busy. So thank you so much for the opportunity to discuss with you many of these issues that you advocate for. I certainly am passionate about these issues, and I know that many of my colleagues will really enjoy hearing from you directly about these issues. So thank you so much again for being my guest today.
It is my pleasure, Maya, and thank you very much for all the work you do, and to all of your colleagues for continuing on this.
Thank you very much.